Okay, ladies and gentlemen, gentlemen and ladies, ladies and gents, we're going to bring this up to about a 10 for right now. If it's going to play. Because I can't hear it, can y'all? And I know it's playing. Oh, it ain't playing. There we go. Some of y'all going to know this song. Get rid of that. We're going to let it play for a moment. Because I got something I want to show y'all. Okay, this is Tupac's instrumental, Hail Mary. Come with me. I want y'all to come and take a trip. Y'all ready to take a trip? I keep telling y'all, this man, he just knows stuff. I don't know how he knows stuff, but he knows stuff. Do y'all want to get this party started? Do y'all want me to prove to y'all that these stupid mother are still dealing with the age of majority? Y'all want me to prove that this is what they're doing every single day? Well, I tell you what, I'm only gonna prove part of it. Then we're gonna play a little bit of a mix here, a soulful mix. We're gonna start with Lenny Williams, Cause I Loves You. But that's gonna come in a minute. Got some things I want to show y'all. See, we've been doing a little bit of definitions. Those y'all who are working on mortgages, this is definitions, title 7, chapter, 25, part 3565, subpart A, general provisions. And it gives us definition, tells us what an approved lender is, an assignment, assistance, a borrower, a claim, a conditional commitment. There was one that was really important. Let's see. Eligible? No eligibility. Fannie Mae? No. We're going to talk about the Federal Home Loan Bank System. We're going to talk about that later. That's also in the suit. We're not going to talk about the foreclosure Freddie Mac. Ginnie Mae. I'm sorry. Gimme! Anyway, we're not going to do that. Oh, now I get it. Oh, see, people say about the voices and everything. See, I'm sorry, y'all. That's just me. I'm not making up anything, trying to be this, trying to be that. I'm just being me. All right, let's go. A holder, person or an entity other than the lender. Whoa, other than the lender? Do y'all see this? It says a holder, a person or entity other than the lender. Who owns all or part of a guaranteed portion of a loan. Whoo, lordy. Then we have the Housing Finance Agency. The FHFA, the Federal Housing Finance Agency. That's where you're going to find when we pulled up those suits, many of them coming from the FHFA. Now, we don't want to do any intrides. We don't do interest credits, land, lease. Nope, we don't want to do lender agreement, loan guarantee, and loan guarantee agreement. Pay attention, ladies and gentlemen. A pledge to pay part of the loss incurred by a lender in the event of default by the borrower. So we don't have to prove, ladies and gentlemen, that they've been paid. There is insurance out there to cover them in the event of a loss in case the borrower defaults. So their notice of default is proof of the implementation of this guarantee. Now, wait. Loan guarantee agreement, a written agreement between the agency and the lender that contains the terms and conditions of the guarantee with respects to the individual loan. Ladies and gentlemen, that is the security provided by the United States government, the guarantee by the United States government. See? Maximum guarantee payment. A maximum payment the agency under the guarantee agreement computes by applying the guarantee percentage times to allowable claim amount, but not to exceed the original principal amount. Now, let's go on. There's more. That's not the only one. Note. We don't want to do note. Payment, permanent loan, prepayment, project, no. Real estate owned, no. Recourse. We don't need to do that one. But let's do it a rural area. Okay? Rural area. A geographic area as defined in Section 520 of the Housing Act of 1949. So it's not a geographical area as defined by you today. Downtown Los Angeles is considered a rural area. We're going all the way back to 1949. Many of the neighborhoods you live in were underdeveloped in 1949. Rural area, rural development. Yeah, see, a mission area within the USDA, which includes this one right here. See, rural housing service within the rural development mission area. Then it tells us what's next. Rural utility services, rural business cooperative services. So it even includes businesses. Wait, let's see what a tenant is. Don't y'all really want to know what a tenant is? Then we're going to talk about U.S. citizen. Okay? U.S. citizen. A tenant, an individual that holds the right to occupy a unit in accordance with the terms of a lease executed by the project owner. Project owner. Doesn't say property owner. Project owner. You live in the projects. That's right, they were called projects for a reason. You're a tenant on your own property. Talk about that later, much later. United States citizen, U.S. citizen, an individual who resides as a citizen in any of the 50 states. The District of Columbia, the Commonwealth of Puerto Rico, the United States Virgin Islands, Guam, American Samoa, the Commonwealth of the Northern Marianas, and the federal states of Micronesia. Never been there. Don't even know what it looks like. The Republic of Palau and the Republic of the Marshall Islands. These are the definitions that you should pay attention to. And the code source right here. Now you see this one right here? This is Title 5. Administrative Procedures Act. Now, ladies and gentlemen, we don't want to go to Title 5. I didn't ask it to go there. Well, let's go there for a second so you can see this Administrative Procedures Act. Okay? Organization. That's what it deals with. Everything is administrative. Departmental regulations. This is all administrative. And I know it's going to say administration in some form or some fashion within here. Whoa, military development. Executive department. The head of an... Look at that! Again, we all know it's already all military in the first place. See, executive department, that's the president. He's the chief executive. He's also the commander and chief of the United States military. We got so much that we can talk about, but we don't want to get distracted. We're going to get back to why we did this video. Why I'm telling you to come with me. Why? Because everybody else was talking about the stuff that I was talking about, but they were talking about it before me. So we went here. What's here? Ladies and gentlemen, we're going to come back down here. Remember, we're going to notification of death of conservative minor. Now, this is the Los Angeles County Superior Court. Because, see, I'm going to be doing some filings there. And so I decided to look up their filing forms so I can put them in my machine right here. This is Wondershare PDF element so that I can sit up here and convert them so that I can get rid of that junk they put in there that I don't need to have. So what did I do? Ladies and gentlemen, I took a trip down here. Okay? I need the bond. I want y'all, we're going to go here, but we want to go there because it talks about bond. That's why I clicked on it for no other reason, but I want to do this one. Come with me, Hail Mary, one quick seed. Do we have here now? Do you want to ride or die? Let's die. Order approving waiver of account and terminating guardianship of the estate. Former minor has attained majority. Ladies and gentlemen, can we get a moment of silence for those individuals who said that this man had it all wrong, didn't know what he was talking about? This man who said to all of y'all from at least 1859 until the present, they've been dealing with minors. So let me tell you I just want you to know that I just found this wording today. I never looked at this form. I kept telling everybody you need to be in probate court. Y'all heard me say that. As a matter of fact, let's do that. We got to go to one of my folders. We're going to go here first. I got to do a quick search for something. We're going to go to my external 2 terabyte hard drive because I need an external, don't need no downloads. We're gonna need documents, okay? What I wanna look up for is emancipation. The petition for emancipation, but I need the emancipation of the infant estate. This document here. Now you notice they're all done right about the same time. So let's do this one. We're gonna do that one. Microsoft 2016 is what's coming up. I gotta change the color, so y'all give me 1 second. We go there, we go there, and we go there. Now, we let y'all know about the 4Share site. You see, this has already been up on the internet for over almost 2 years now. Did anybody ever read this? Look, a petition for emancipation of an infant must conform to the applicable statute. Such proceedings are generally commenced by a petition in writing. Denial of infancy. That's me putting that there. The petition must state all the necessary jurisdictional requisites. It generally must state that the minor resides in the county in which the proceeding is brought, and that the minor is managing his or her own affairs. The petition may, however, be sufficient without alleging that the relief sought will be in the interest of the minor. It is sometimes required that a petition be sworn by some person cognizant of the facts set forth in the petition. On filing a sufficient portion or petition to the jurisdiction of the court attaches. Okay, ladies and gentlemen, this is what we want. Okay? The next sentence, we're going to make this a little bit bigger so y'all can see bigger, so they don't have to strain y'all eyes. There must generally be a hearing on an application for the removal of minors' disabilities, at which such petition may be contested. Ladies and gentlemen, this is what I had originally. I didn't have the whole corpus juris secundum. I just had this section of laws. That's why I put it up immediately when I had the opportunity, when they released me. Okay? The judge ordering the removal of minor's disability has the implied authority to determine the existence of all the facts of which the validity of the order depends. General rules governing the evidence in civil proceedings ordinarily apply to proceedings of the removal of disabilities of minors. Okay? Remember, there must be a disaffirmance. And honestly, if you're going to do a petition, attach the affidavit to it. That should be more than enough information in there to take care of things. Now, what I want to let you know, because we got to talk about probate court, because remember, we came to this document because we're on probate. Okay? Generally, an infant may acquire property. That's how we were able to show you about an infant acquiring property. Okay? What I'm looking for, inherent. Oh, and I love the intermeddlers. Individuals intermeddling with the estate or property of an infant. You can bring that claim up in this court. But there's my word, inherent, y'all. Let's find out about jurisdiction. Jurisdiction over the estate of an infant is inherent in equity, but it may also be vested in constitutional and statutory provisions of a particular court. The institution of proceedings affecting an infant's property makes the infant a ward of the court state. See, the institution of proceedings affecting an infant's property makes the infant a ward of the court. That's every time you go to court, which has broad powers and duties to protect his or her interests. Okay? But what if I bring it in probate court? Does that make me you're demanding emancipation, that you've already been taking care of your own affairs. You're gonna have to read this. This is up on the 4Share site. The courts of equity have general and inherent jurisdiction over the property of infants. Well, ladies and gentlemen, let's find out what those courts are. Primarily, jurisdiction over the estate of infant may, under constitutional or statutory provision, be vested in probate, county, district, or other specified court, county or superior court. District courts, be it the state district court, or because some states like New Mexico, their superior court is called district court, or the federal district court, or other specified courts. Bankruptcy court. Bankruptcy court is a court of equity. See, inherent jurisdiction is an equity, ladies and gentlemen. Equity. It's all equity. So, now that we have that out of the way, of course we can save that. Come with me. Run quickly. Let's see, where did I say we were going to go? Oh, let's do this, because I need to educate y'all. This video is going to be about another 5 minutes, but we're going to do the Emancipation Proclamation. Does anybody know when the Emancipation Proclamation was done? Did you say 1863? Well, you'd be right. If the Emancipation Proclamation was a presidential proclamation, an executive order issued by the President Abraham Lincoln on January 1st, 1863. Ladies and gentlemen, in 1863, what war was going on? Did you see that? It was the Civil War. When was the Emancipation Proclamation signed, and how did it shape the Civil War? Everybody thinks the Civil War was a war between the North and the South over slavery. Ladies and gentlemen, I bet y'all didn't know that it really was over slavery. It's just not the slavery you think. Let's do this. Now, when was the 13th Amendment enacted? Let's do that. Year of enactment. Well, we can do year passed. Let's do year proposed and year ratified. Well, that's not the original 13th Amendment. The original 13th Amendment, blah, 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 blah. Ladies and gentlemen, I don't care about people saying that the original 13th Amendment talked about titles of nobility. I could care less about that. We're talking about the 13th Amendment as it applies to the Emancipation Proclamation. Neither slavery nor involuntary servitude. Please understand, the Civil War was dealing with slavery, but it wasn't dealing with color. And that's what you all don't realize. The international law prohibiting slavery had nothing to do with color of skin and literally having people as slaves tied to chains and whipping them. That was not what it was about. Then what was it about, Mr. Jones? I thought you'd never ask. Let's see. It was about slavery. Minorship. Being wards of the state. Oh, by the way, pay attention. For use when no funds held in blocked accounts. Excuse me? Yeah. Remember, it said the person petitioning the court becomes a ward of the court. That means the courts have. Let's do that. I gotta show that to y'all because I showed it to you once before. We got less than 2 minutes. So SOVEREIGN guardianship. Does anybody know what sovereign guardianship is? Well, if you take a look at the corpus juris secundum information I sent you, you'll know that the sovereign power of guardianship. That's it right there. That's that word we found in corpus juris secundum. Y'all do remember that, don't y'all? Sovereign power of guardianship. It's that PP word right there. PP. Where's the PP? There it is. Parentis pariah. I hope that's pariah, but it sounds like pariah. They're pariahs! Sovereign guardianship. It just means that the state has the power of sovereign guardianship to handle wards of the court. So, ladies and gentlemen, guardianship, minors, age of majority, on the money. Got it? Good. That was your quick update on the age of majority and mortgages temporarily mortgages. We have more videos coming up real soon. Said 20 minutes, and we're right there. I'm going to cut it short, so it'll be just less of 20 minutes. Or shy. Bye.